Welcome, everybody. I'm John Haig. I am the co-director of the Mosavar Rahmani Center for Business and Government. It's great to see all the faces here, certainly some familiar faces. And as I usually say, we have a double whammy today. We have food, which is usually a very good attractor, and we have a terrific topic and a terrific speaker. So a couple things. We're going to talk about the Google search case, and John will walk you through it, Jon Sallet. But a little bit of background on John's background. One, he is a senior research fellow here in the center and has been for a number of years. But for this purpose, the most important thing is that he is one of the key litigators in the Google search trial. He worked for Phil Weiser, who's the Attorney General of Colorado, and he worked with the Department of Justice attorneys. And the DOJ attorney and John basically were the lead people examining, cross-examining witnesses in the Google search trial. So we're going to get a very unique and very valuable perspective on the whole trial. He'll go through the details. He and I are co-teaching a module this fall, second half of the semester on big tech and competition, BGP 215M. I'm not encouraging you to sign up necessarily because we're close to like full, but we are teaching that. He's had extensive government experience as well, working at the DOJ as a district deputy assistant attorney general for litigation in the antitrust department. He also has worked for one of our other fellows, Tom Wheeler, as the general counsel for the Federal Communications Commission. We could have a whole separate conversation about that topic right at the moment. And he has extensive, and I was going to say, we do have a little more planned today. But today will be Google search. A couple things I wanted to mention. 4 o'clock today, Gene Kimmelman and Tom Wheeler are going to talk about Jimmy Kimmel and the issues there. We hadn't exactly planned on having that succession, but events overtook us, and we thought it was pretty critical that we have some conversation about that. So you're welcome to come to that as well. I will say mid-October, this is one in a series of talks that we give out of the center. In mid-October, Gene Kimmelman, who also has antitrust DOJ experience, is going to talk about Europe and the Digital Marketing Act and a little bit of Digital Services Act. So one way that we think about it is if you want to shape competition, you have kind of three tools, right? One tool is the US approach of competition policy, where it's ex post the harm. Then you have the European version, which is more sectoral regulation. It's ex ante, setting standards of behavior. And then you have industrial policy, and all three are ways to shape competition. And so mid-October is Europe. November, we're going to talk Tom is going to lead us on AI. But perhaps as importantly, mid-November, you will hear from people beyond John about the Google search case and the Google situation. So that panel will be myself, Nancy Rose, who is here in the front row. Nancy's a professor in the economics department at MIT, former chair of the department there, and also had been at the Department of Justice as the chief economist overseeing antitrust. Gene and Tom, and potentially Jason Furman, who will give a slightly more conservative perspective on the decision and its pluses and minuses. With that, John, it's all yours. We'll try to leave some time at the end for questions, but it's all yours.
Thank you, John. I went to my first meeting of states about the potential for a Google search case in February of 2020, a long time ago. The case progressed from there. Let me just give you a quick overview of what happened. In October 2020, the Department of Justice filed a complaint saying that Google had violated the law, the Sherman Act, through the use of exclusive distribution contracts. In December of 2020, a group of 38 states and territories filed their own complaint. That's the case that's called Colorado versus Google. That's the case in which I'm the lead counsel for those states and territories. The case progressed. Big antitrust litigation involves lots of fact gathering, questioning, experts, preliminary phases, but it all led to a liability trial in the fall of 2023. Went from September to almost Thanksgiving. I think 11 weeks, but lots of witnesses and documents and exhibits. And that resulted in a decision in August of 2024, the liability decision. I'm going to refer to it as such. It's the decision where Judge Mehta, who presided over this case in federal district court in Washington, D.C., determined whether Google had violated the law. And he determined that Google had. And I'll explain that. But we, the government, the Department of Justice, and Google had all said to him, if you find that Google violated the law, then we want to have a separate part of a trial to decide what to do about it. And that's what's called the remedies phase. And so it kicked off in September of 2024. More discovery, more experts. We made proposals. The states I represent alongside the DOJ about what to do about it, what remedies to ask the court to impose. April and May of this year, a trial, a 3-week trial, I think, 50 witnesses in the district court in DC, and then closing arguments at the end of May. We in the Department of Justice asked for a series of remedies. Google asked for different ones. I think it's fair to say, I don't think this is a lot of disagreement, lesser ones than the government proposed. And on September 2nd of this year, the judge issued his decision. The governments didn't get all that they asked for. And what I'm going to talk about today is that what I'm going to offer you today is a perspective and some questions that people should think about, informed by your own readings, informed by the panel we'll have in November, about what you make of all of this, both the liability decision and the remedies decision. But before I do that, let me just be clear. I'm offering my personal views on the Google search case. I'm a Special Assistant Attorney General for the state of Colorado. Colorado's free to disagree with me, right? I'm personal views. I want to talk to you about this case because I think it's a landmark case. It's a very big monopolization case involving a big tech firm at a time when there's a number of cases and lots of interest in the competitive consequences of big tech conduct. But I want to be plain about this. Don't take my word for anything. Read the judge's opinions. They are long, but they are very readable. They're both, I think, between 200 and 300 pages each. Very detailed, worth understanding. I'm going to give views that, not surprisingly, are not going to be the same, I suspect, as Google's. But listen to what Google has to say. Think about what Google is saying about this. If I say the judge did something, think about how Google would respond and read what they say. There's been a lot of commentary after the liability opinion, a lot of commentary after the remedies opinion, coming from a variety of different sides. Make yourself acquainted with that. And at the end of the day, reach your own views. This is very important because this kind of case can shape or not shape the American economy. And as students of public policy, understanding what you think is the right way it should have come out is very important. The case is about how Google kept competitors, other general search engines, think Bing, think DuckDuckGo, from getting to users, getting to like us in this room. And the users that their rivals needed to be successful. And we're going to talk about the importance. Everybody needs customers, but there's particular importance of users here because they don't just use the product, their presence improves the product. And we start with the notion, the judge gave this number, that Google's share of the general search services was nearly 90% in 2020. As a matter of US law, that's a monopoly. But it doesn't mean that Google by itself had done anything to harm competition. That's a separate question. And this was the answer, that Google had contracts that violated the law, that closed the most efficient pathways by which Google's rivals could reach users. What's a pathway? For today's conversation, I'm going to emphasize browsers. It's not the only one in the case. I'm going to emphasize default settings on browsers, not the only conduct in the case, but at the heart of the case. Most people here, I suspect, use a browser to get to a general search engine. Some people may have downloaded search engine apps, but browsers are a very familiar way to reach a search engine. And you all know that when you open up a browser for the first time and you type a question or query into the toolbar, there's already a general search engine set that will provide you with a response. So we need to understand a little bit about what that means. In other words, how do the illegal contracts hurt competition? They hurt it by the defaults that are preset in the toolbar that you can all change, but that the judge held had very significant competitive consequences. One that he called was a major and largely unseen advantage. Unseen because users don't have to do anything. It's there when they start. The default is extremely valuable real estate. I'm skipping among quotes, but most users access a general search engine through a browser like Safari or a search widget that becomes preloaded on a mobile device. They're set to a default search engine. Many users simply stick to searching with the default, and Google receives billions of queries every day and derives extraordinary volumes of user data from such searches. That's my point, that it's not just you use the product, your presence improves the product. You give data to a general search engine, which can use that data to improve the quality of its searches. So Google pays a lot of money for these defaults. And this became, I think, a central question in the trial. Because ask yourself, why is Google spending billions of dollars for these defaults? Let me just take a minute and describe it. This is Apple. Google pays Apple $20 billion in 2022 to set Google search as the default on the Safari browser, okay? In 2021, these are, I think, not entirely consistent numbers because this is a worldwide number, but in 2021, Google paid over $26 billion to browsers, Safari, Mozilla, manufacturers, think Android, Samsung as a manufacturer, Motorola, some people may use, mobile carriers, AT&T, Verizon, T-Mobile, all of whom are getting different forms of revenue sharing payments to give some preference to Google. This is what the liability trial was all about. And there was a particular day, I don't know if you know the way the courtrooms are set up, but in the well of the court, where the public is not allowed, there are big counsel's tables, right? So I was sitting in counsel's table, that was my job, when perhaps the single most striking testimony of the liability phase was made. And it came from a man named Sridhar Ramaswamy. He was the CEO of a company called Neeva. Anybody here ever use Neeva? This is why it wasn't successful. It was a search engine, general search engine, had a different business model. You paid a monthly subscription and there were no ads, right? People here use Netflix. Some people probably pay extra so there's no ads. Well, that is the kind of business model Neeva populated. Other general search engines have ads. If you didn't want ads, you'd pay a subscription, and you could use Neva without ads. So the way these trials work, these are so-called bench trials. There are no juries. The judge is the finder of fact. The judge can ask questions, and throughout the trial, Judge Mehta did. One day he said, when Dr. Ramaswamy was testifying, why Google pays billions of dollars in revenue share when it already has the best search engine? And Dr. Ramaswamy said, the payments provide an incredibly strong incentive for the ecosystem to not do anything. They effectively make the ecosystem exceptionally resistant to change, and their net effect is to basically freeze the ecosystem in place. And that was kind of a moment sitting in the courtroom where you thought, oh, this resonates. We're going to hear about this again. And the judge commented, in his opinion, no one would ever describe a competitive marketplace in these terms. Well, how does this tell us anything about what remedies there should be in these contracts? At the risk of being hopelessly self-referential, I'm going to quote myself. My wife, Lori Sallet, is here, and she's already heard this line. So if she doesn't laugh, it's just because she's heard it before. But at the opening arguments in May, I stood in front of the court in a lectern like this, except there's one judge looking down. And I said, referring to the fact that the Google payments freeze the ecosystem in place, I said, our remedies are antitrust, anti-freeze. That's what we're trying to do. We're trying to open up the ecosystem. It won't take days, it will take years. But at the end, competition can be restored, consumers will be served, and we will fulfill the promise of American antitrust. This was a big concept. So when we get to remedies, here are some questions. There's dozens of questions about remedies, okay? But here's a couple of big questions. Have the remedies opened the most efficient pathways to users? The judge says that the defaults are the most efficient pathways, right? For a general search engine to read users. Have they been opened up effectively for Google's rivals? And in particular, because I hear from the introductory remarks that people these days are talking about Gen AI, have the pathways been opened up to Gen AI? We're going to take a few minutes to talk about this. But first, I need to do a minute on the law, and I apologize for that. When John and I teach the course this semester, as we did last year, we emphasize you don't have to be a lawyer, an economist, a technologist. You're a public policy maker, and you listen to lawyers, economists, and technologists. But one of the things the lawyers will come into your office and do, as I did when I worked for Tom Wheeler, is say, here's what the law is. Here's what the law of remedies is. And we know because Judge Mehta said this. He told us it's the duty of the district court, upon finding a violation, to redress the violation and restore competition. He said the remedy this is a Section 2 enforcement action, that's the legal statutory violation. It's the part of the Sherman Act that was violated. The remedy must seek to unfetter a market from anti-competitive conduct, deny the defendant the fruits of its statutory violation, and ensure there remain no practices likely to result in monopolization in the future. So let's set the stage. Here's the conduct. The distribution agreements provided exclusive pathways to users for which Google paid billions of dollars. By the way, let me just say, Google thinks this is wrong. It has said it's going to appeal this, okay? I'm taking it as given because the judge said it, and I think it's right. But this is a contested issue. But as a matter of law, this is what the judge decided. We've talked about browser defaults, other forms of preferential treatment like the widgets. I'm just going to use the term default. So what happens as a result of this? The judge, in his remedies opinion, gives us examples. Google gains freedom from competitive threats. It gains more users, which translates into more scale. It receives monopoly revenues. And although we didn't call it out specifically, he did recognize that it disincentivizes Apple in particular, from entering general search. So let's think about the contracts. He says Google's exclusive distribution agreements have allowed it to operate free of any genuine competition for more than 10 years. At another moment in his liability opinion, he said there's been no real new entry for 15 years. Neeva fails, DuckDuckGo, which people may use, has a very small share of the market. And Google has said, if you eliminate the contracts, we're going to come back to this, job done, right? No, we're doing bad stuff, we stop doing the bad stuff. The judge specifically disagreed with that. It's very important for what you're going to think about. He said to appreciate the full effect of these contracts, however, one must look beyond their express terms. Lawyers, when you're public policymakers, are going to come in and they're going to say, this is what this word means. And you're going to say to the lawyer, yeah, but what are the practical effects? What are the marketplace realities? And the judge went on to talk about two. Google's unlawful agreements allowed it to capitalize on two powerful forces, default bias and network effects. So let's take a minute to talk about both of those. Default bias. Default bias means that user habit and Google's well-known brand and what's called choice friction, the difficulty, switching costs. If there are people who've taken economic switching costs, all make it less likely that people will change. But there's another point. This is Professor Michael Luca. He's at Johns Hopkins University, and he was our expert behavioral economist. And the judge noted that he testified that search engines are, at least in part, an experience good. What's an experience good? You kind of got to use it to know if you like it, right? That's not uncommon. But what it means is, if I'm the seller of an experience good and I can't get in front of customers, then they'll never experience it. And if they don't experience it, then it's far more less likely they will ever ask to use it. So this is an effect in the marketplace. Second thing, I'm going to say this even though Nancy Rose is here, and she's going to teach the economics session of the class John and I are going to teach in the fall because she knows better than to leave it to me or John. But this is sort of economics. Network effects. They look like that. The judge said the exclusive agreements secure distribution to secure even more circles, thereby perpetuating this cycle. Why does it perpetuate it? Importantly, because of a set of effects that flow from the advertising model that Google and frankly a lot of big tech companies use. Okay? So let's go around the circle. This is actually from a Microsoft document that was in an exhibit in the case, and the judge put this in his opinion and has referred to this idea of network effects repeatedly. Here's where it goes. If you get more users, then you get more advertising because advertisers would like to put their advertisements where there are people to see them. But also, you get more data. This is the data point we talked about before. More users equals more data. Now, more advertisers is a very good thing, but more data allows you to build better search and more relevant ads. In other words, ads that people will be more likely to click on. So the increased data is increasing the quality. Now you get more quality, so you make more money. And you can put it into development to make a different, better product, but you can do it in distribution. Distribution means paying for the defaults. And so when you come around to pay for the defaults, you have more revenue because you've gotten more users. And then you get more users again, and the cycle continues to spin for Google. but not for everyone. What for Google manifests as a dazzling flywheel of queries and quality has the opposite effect for rivals. It keeps them stuck in place, or at worst, causes a downturn spiral of scale and revenue. So the network effects are very important, and they're ongoing, right? They're not just one time. The whole point of them is that it is a flywheel. It turns. So these two effects stay in the marketplace. Now the judge looked at these effects, and he imposed, I'm going to start talking about what he did. He limited the way Google could make default contracts. For example, he said they had to be terminable after 1 year. If a company granted Google default after 1 year, it had to have the right to go to a different general search engine. But very importantly, and this is consistent with the quote before about default bias and network effects, where Google said all you got to do is stop the nature of the contracts, the judge said no. Merely excising the exclusive provisions from Google's distribution agreements will not unleash competition. Google simply retains too many advantages that are derived in part from its decade-long vice grip on default distribution, including what we've talked about: quality, data, volume, capacities. And by the way, these advantages are particularly pronounced for mobile search. Default is stronger on a mobile device, in part because of the form factor, right? The size is different. So the judge is saying just changing the contracts by definition is not enough. So what's the next thing the judge thinks about? More users equal more scale. We know that, right? From every time the flywheel goes around. And so he tells us users enter 9 times more queries on Google than on all rivals combined. On mobile, 19 times. Google's market share is larger on mobile than desktop. And in fact, that difference of 9 times more query means Google has something like almost 18 times more data than Bing. Think about unusual phrases. There was one test that the judge relied on where it showed 93% of them were seen solely on Google. And then think about long tail, local, and fresh, right? Long tail queries, people very ever enter into a general search engine. Let me think of an example. Oh, who's Jon Sallet? That would be a long tail query, right? A local query. What are good restaurants in Cambridge? That's important because having great knowledge of what's a good restaurant in New York does not allow a search engine to answer anything about a great restaurant in Cambridge. And then fresh. News. There's news events. Think of COVID in early 2020. In late December 2019, I bet there were very few people searching for the term COVID. It burst upon us. And so with more data, more users, more scale, Google gets the better answers to those more quickly. What did the judge do about it? He ordered the sharing of some Google data and the syndication of search results in text ads. In other words, there's some of Google data. A good example is the so-called search index. You may know about it. It's how Google searches the web for information, creates an index that it can consult to see which websites, this goes back to the original invention of Google, PageRank, which results are going to be the most relevant to users. It can syndicate. So for example, DuckDuckGo syndicates Bing search results. If you use DuckDuckGo, most of the search results, I believe, are being supplied by Bing. And the judge said making data available to competitors would nail the scale gap and we'll come back to this, in turn, the quality gap that followed. So more data, the judge says, better quality. We asked for more than the judge ordered. He has a very detailed discussion of why he made certain decisions along the way, but he clearly orders that which he thinks will help improve quality. So, what did we ask him to do? We focused on this question, the most efficient pathway. How we focused on other areas, but what I'm going to turn to now is where we focused. And when I say we, I mean the remedies that were jointly proposed by the states I represent and by the Department of Justice and states that were part of its complaint. We proposed a set of different ways to allow rivals to get to users in an efficient way. First, ban Google from paying for default. Don't let them pay for default. They can pay for other stuff. They can pay for marketing. If they want to help Samsung or any other company market, they could even in some circumstances pay users directly, but don't let them pay for defaults. Okay. Secondly, we emphasize the fact that Apple is a company that has the capacity to enter general search itself, which is a whole different form of competition. And thirdly, we asked that the Chrome browser be divested. So the judge didn't grant these. I want to take a minute to go through his reasoning and some questions I think that can be asked and ought to be discussed and thought about. First of all, Judge Mehta very clearly pointed out what the point of the payments ban was that we sought. The rationale for a payment ban is straightforward. It would pry open the market to competition. And I think on the legal slide, there's language used by courts. One of the goals of the remedies is to pry open competition. So he recognized that rationale. He said the revenue share payments, the payments for defaults. Well, I don't need to read this language to you. This is Dr. Ramaswamy. He quoted Dr. Ramaswamy again. And he was thinking about Dr. Ramaswamy because he said, a payment ban in theory could bring about a much needed thaw. I was not personally hurt that he didn't use my antitrust antifreeze description of this, but it's the same idea. The payment ban could do this. He did not ban the default payments. And I want to take a minute and go through what I understand to be the reasons why. Google won't be barred. Cutting off payments from Google almost certainly will impose substantial, in some cases, crippling downstream harms to distribution partners, related markets, and consumers. So for now, Google will be permitted to pay distributors for default placement. He went through the reasoning like this. He said, if Google couldn't pay, then let's just talk about, I'm going to use browsers as a form of distributors. Then the browsers would either have to put Google up for free, or they would go to what he said was a lesser quality general search engine to get some money. Now, when he's talking about downstream harm, I understand him to be saying the payments that the kinds of payments that accompany the improper contracts, paying for defaults. The money goes to companies like Apple or the mobile carriers in the United States. And if you cut them off from those payments, then the judge worried that there could be harm in markets for browsers or potentially smartphones and to consumers. But remember, I would ask you to consider the fact that the downstream farm here all runs to lower payments whose earlier payments were the illegal conduct. And how do we take that into account? I'm going to come back to that. But so we read the judge's opinion and we see that he's not accepted the payment ban. So we naturally ask ourselves, if Google holds the defaults, how will competitors reach users, right? That's a logical question because the whole liability case was centered on keeping rivals from reaching users. These new realities, let me just say, please you read this yourself. There's an interesting passage on pages 127 and 128. He describes investment that's going into Gen AI. He describes the possibility that Gen AI could become an entry into general search and could therefore make money the way Google does, monetizing queries, probably selling ads. These new realities give the court hope that Google will not simply outbid competitors for distribution if superior products emerge. This is a hope. There are some ifs in this sentence. If the general search, if companies like OpenAI and ChatGPT, if they enter the market, if they build a superior product to Google, if Google, incentivized by the importance of maintaining the default and with a monopoly, doesn't choose to outbid them. These are important ifs. And what we know from the history of this very company and antitrust is that the hopes aren't always realized. In 2013, the Federal Trade Commission, the other federal antitrust enforcer in the United States, had an investigation of Google. It closed the investigation without taking, I think it's fair to say, significant action. Why? Well, largely because it anticipated that as mobile became a big deal, as people got off their desktops and search was performed on smartphones, that there would be more competition. But in fact, companies that were talked about like Mozilla and Microsoft or Amazon did not come up with their own operating systems. And so we have two mobile operating systems in the United States, one of which is the subject of the payments we've talked about, the other of which is, of course, Google itself for these purposes. And rather than mobile having more competition, bringing more competition, there's less competition on mobile. Google has a 95% market share with stronger default effects. And this is the genesis of the scale number, 19 times more queries on mobile than in desktops. So the other question we can ask is this. The judge anticipates a world where he hopes the Gen AI companies would have superior products and be able to outbid Google. Well, Bing is a company that can bid for these. There could be multiple Gen AI companies. There's certainly multiple ones working on this issue now. So one question to ask is, if a Gen AI comes in with a superior product, or multiple do, why do we need Google to make sure that there's payments to browsers? Won't competition between these Gen AI firms and Bing supply competition? And might it be advantageous to allow that competition to lead to payments to browsers without giving Google the chance to keep the defaults locked up? That's an important question. So Gen AI, it turns out, is a big topic. There's been a lot of discussion of the remedies opinion. I think maybe too much emphasis on the role of Gen AI in leading the judge to the particular remedies he chose. It's not that Gen AI isn't important, but I want to give you some context that I think demonstrates the world as I understand Judge Mehta to have seen it. First of all, Gen AI. Did I skip one? No. Let me just take a minute to talk about what Gen AI is. I apologize. Basically, the judge is talking about Gen AI as doing one of three things. Gen AI can be a feature on a general search engine. AI overviews on Google, Copilot on Bing, right? You go to your search page, there are the search results, but there's also an AI supplement. Secondly, you can have your own chatbot. Anybody who uses Perplexity, for example, you can go download an app and you use Perplexity. And then thirdly, a chatbot, particularly AI, as the new agents emerge, which is what companies are working for, maybe it becomes another pathway to search, right? The way browsers are a pathway. For competition analysis, I think the judge puts more emphasis on the chatbot, ChatGPT, Claude from Anthropic, Perplexity, and others. And what he tells us is they're a potential threat to Google's dominance, but not a current threat. Has Gen AI replaced Google search? No. Now, there was some testimony at trial about this that was extremely interesting. A very senior executive from Apple testified that the volume of Google search queries in Safari declined for the first time in 22 years, perhaps because of Gen AI. But the judge followed quoting that testimony with this. But Gen AI products have not eliminated the need for general search engines. In fact, AI overviews has potentially strengthened Google's position. Since its introduction, Google search queries in the United States have increased 1.5% to 2%. Thirdly, do Gen AI models depend on established distribution channels? They do. This was a lot of testimony at trial about how they could get onto browsers, for example. And there have been some small deals made with Motorola, for example. But the judge specifically, I'm so excited, I couldn't keep the microphone on. Sorry. I'll try to calm down the rest of the way. Microsoft has incorporated AI into its search products, but no new distributor has selected Bing as a default. So, although he says rival Gen AI products have had some success in obtaining distribution, AI has unquestionably improved general search, but it has not yet altered fundamental market dynamics. And the last one, does AI need the remedies? In other words, is AI an independent force in the universe that has nothing to do with, doesn't require any of the assets or distribution channels that Google has? No. This is from the first page, goes to the second page. This first sentence has been quoted a lot. The emergence of Gen AI changed the course of this case. And later, the judge says, well, Gen AI in some ways made the remedies I'm going to order more palatable. What gets quoted less is the end of this paragraph. These remedy proceedings thus have been as much about promoting competition among general search engines as ensuring that Google's dominance in search does not carry over into the Gen AI space. Okay, the judge amended the remedies order to provide additional opportunities and protection for Gen AI under the remedies decree. So Gen AI is an important thing, but there's still other forces to play. It isn't immune from the Google ecosystem. And because anytime anybody's paying for distribution agreements, remember monopoly revenue. The judge says Google has used these monopoly profits to secure the next iteration of exclusive distribution deals, such that Google's distribution partners cannot afford to go anywhere. So the flywheel, we're back to the flywheel one more time. Perpetuating the cycle with more and more revenues. These are my words. I want to just say there's no quotation marks in here. I'm not attributing this to the judge. With more and more revenue from the illegality, the illegal contracts, as the wheel spins. The judge says a payment ban would be one way to deny Google the fruits of its statutory violation. The fruits, meaning the product, what comes as a result of a violation. But there's sort of a question that should be asked here, or could be asked here too. Imagine this. There's a monopoly. It violates the law. It makes more money as a result. It does so by working with another company. So it takes some of the monopoly profits it made as a result of illegal conduct, and it offers to split it with this other company. Then the company says, you shouldn't cut me off from the payments. I'm using them for good stuff. Well, is that a good argument or a bad argument? Is it a good argument because there's been some expectations of the payment? Is it a bad argument because using illegal monopoly profits to split revenue or to do other things doesn't turn them into good things? The money has been illegally derived. And for those of us of a certain age, the AT&T breakup decades ago, think about the AT&T breakup. AT&T was doing great stuff. It was keeping some telephone rates low. It was doing tremendous research in Bell Labs. But it wasn't a defense that the AT&T was getting money through violations of the antitrust law and spending it for something people liked. So I think the nature of the payments and monopoly revenues is important. I want to just skip a couple of slides because I do want to leave time for questions. Well, I'm going to try to go. Just this other one. Isn't Gen AI doing great? I mean, what's the problem? Well, the judge says Gen AI chatbots are a potential threat to Google's dominance. What makes a potential entrant a potential entrant? Potential, right? Potential is a good thing. Gen AI has potential, but Gen AI chatbots are not now substitutes. And remember, the forecast for mobile didn't work. But I think also importantly, the presence of potential entrants doesn't mean remedies don't have to be strong. It means there's a better reason maybe, or a good reason why they should be strong, because effective remedies will work best if there are potential entrants or nascent competitors that can take advantage of the remedies to restore competition to the market. Two other things. Apple. The judge held that the payments to Apple disincentivized it from launching its own search engine. And he said a payment ban could encourage new entrants, including Apple. This is why I called out Apple specifically, because Apple, alone among the companies that were getting payments, was found to have the capacity. This isn't, maybe they'll develop the capacity, have the capacity to enter. And a payment ban would have increased the incentive. That's the position we in the DOJ took. And then Chrome. So I argued a bunch of the Chrome closing argument, and we didn't get the divestiture. And the judge gives a number of reasons, but he also asked a question of the Google counsel during that. He said, This, in some sense, meaning the Chrome divestiture, from a judicial standpoint, a little cleaner and a little bit more elegant and a little less speculative than the other remedies. Would you agree with that? I want to be fair. The Google counsel said he did not agree with it. But it was our point. A great percentage, significant percentage, 40% of US web traffic on mobile goes through Chrome. We thought by making Chrome independent, that would be a very simple way of opening up 40% of mobile queries to a competitor. The judge felt, I think it's fair to say, that we had reached too far and that there were potential complications. So none of these remedies were chosen. What happens next? Well, Google has said they're going to appeal. And there's going to be a remedies process. The judge says for 6 years. He's also said, and we should think about this, I'm thinking about it. He said, judges must be open to clarifying and reconsidering their decrees. The court is thus prepared to revisit a payment ban or lesser remedy if competition is not substantially restored. But the question is, remember the flywheel. If you put off remedies, does the situation not get better or does it actually get worse? And that's a very important concern. So that's an overview of the issues. I'd be happy if there were to be any to answer questions for a few minutes, or John, however you'd like to proceed. Anybody? All right, John, it's John's room. John gets to ask the first question.
Just raise your hands and Claire will come around with a, so just out of curiosity, you pointed out that the judge basically said that AI changed the landscape of the discussion. So I kind of have two questions. And he said, and I'm reading from unlike the typical case where the court's job is to resolve a dispute based on historic facts, here the court is asked to gaze into a crystal ball and look to the future, not exactly a judge's forte. And I guess two questions. One, if the Gen AI kind of perspective had been available when the original decisions were being reviewed, like was there a violation? Do you think the judge might have found differently? Because there really wasn't any of the Gen AI stuff. And the second question, I guess, is around the impact of AI, Gen AI, on the market. And I just, out of curiosity, I typed into my phone, can I use Perplexity as a search engine? And it came up and said, set Perplexity as your default search engine in Chrome. The extension will allow you to search with Perplexity from your browser URL box, experience lightning fast searches, precise answers, and transparent sourcing. So I guess, where does that leave us in terms of kind of the judge's decision and the impact of Gen AI?
Let's see if I can find it. So first of all, let's talk about the liability decision. The judge held that the chatbots were not in market. AI Overview is a feature in the market. It's not its own product. And search access points are like browsers. They're not in the market. So the presence of other firms not in the market would lead one to believe that the judge's liability decision would not have changed at all. What about the remedies phase? The judge says, Gen AI technologies may yet to prove to be game changers. They're not yet close to replacing general search engines because their functionality only partially overlaps, and Perplexity has some functionality that I think probably the judge would have thought overlaps some. Because their functionality only partially overlaps, Gen AI chatbots have not eliminated the need for general search, but they are a potential threat to Google's dominance. They're out of market. Maybe they'll change things in the future, but to But the judge held, not on their own, that they needed the benefit of the Google remedies, which suggests again the need for remedies that will allow companies, including Gen I, to reach customers through the very best pathways. Anybody else? Yes?
We've heard a bit about the perspectives of different players in this game, whether like other search engine providers and like the needs of consumers. I'm curious to ask, what was the perspective presented by the main ad buyers?
The ad buyers' biggest presence was at the liability phase, and their main perspective was about the question of the market. What was the relevant market for advertising? I know I'm descending into antitrust now, but you have to be a monopoly, you have to know what the market is that a monopoly is in. So is Coca-Cola in the market that's Coca-Cola and Pepsi-Cola, or is it in the market that includes orange juice and water? Okay, that kind of question. The main thing the advertisers talked about at the liability trial was that Google search text ads, the traditional ads on a Google search engine results page, have a distinct value to advertisers, different than what might be a display ad or a Facebook ad or a different kind of ad. And that was important for showing that Google had a monopoly. And in fact, what the judge found was that Google had engaged in techniques, tuning knobs, they were called, that had taken advantage of Google's monopoly hold to increase prices to advertisers above what would have been competitive levels. Okay. So we're close to 1 o'clock. I know people have classes coming up. Absent anything else? Oh, Gene, Mr. Kimmelman has a question.
Thanks, John. This is great. Really excellent. So in the same way, John Haig points out what the judge said about his sense of limited capabilities to understand the market and how it develops. We know the lawyers who investigate these cases also have a lot of unknowns as they're doing them. And you went through this process. And I'm just curious, after the fact now, having been through all of this, is there anything that you, thinking back to 2019, anticipating all this, is there anything that surprises you, you would have liked to have known, or you would have thought differently about having been through the experience compared to what you anticipated and all of your colleagues of what everyone was going to argue, what you thought the evidence was going to be, what you thought a judge was going to be concerned about? Any things that just jump out at you?
No, actually to the contrary. In the summer of 2020, the states that I represent, with many fabulous lawyers from state AG offices, certainly not by myself, we're very focused on bringing additional allegations of conduct to the judge. We did. That's why we filed a separate complaint. The judge found that our separate allegations did not meet the requisite legal standards. But we did that thinking about the remedies phase, not the liability phase only, thinking to ourselves, if it's only about the contracts and the payments, maybe somebody will say, well, just stop the contracts or the nature of the contracts and you'll be done. And that is what Google argued. The judge went further. He obviously didn't go as far as we did. But I guess my answer is, we always thought that the end point was not the liability decision, it was the remedies decision. Okay.
Can I follow up on that in one way, John? So for those of us who were watching from afar, as in way afar compared to you, the liability decision, yeah, boom, understand that. Clear cut, couldn't have been more forceful. The remedies decision, you scratch your head and say, wait a minute, where did AI come in all of a sudden? Do you think that there was sufficient awareness and discussion at both stages of the trial on the topic of the impact of AI?
The first witness we put on at the remedies phase was about Gen AI. Nick Turley testified from OpenAI. Dmitry Shevelenko testified from Perplexity. Google had its own experts talking and executives talking about Gen AI.
Let me suggest that you probably weren't putting witnesses on to say Gen AI is going to solve the problem, has the potential to solve the problem.
Right,
Right.
because
So-
we demonstrated that Gen AI did not have
Did
the
not.
capacity in and of itself
So
to
it has a
solve the problem.
surprise when Meta turns around and delivers his opinion. You go, where did that come from?
Well, you know, I want to be, Judge Matter is a great judge to try a case from. I have not done justice to all of the details in his 277-page opinion. I think that he's got findings of fact on Gen AI. He's got legal conclusions about Gen AI. I think I've expressed my view about this, but this is why I encourage people to look at his discussion of that, because I think it is more detailed and perhaps more nuanced than has been appreciated. And as I say, rests at the end of the day on the conclusion that Gen AI needs the benefit of remedies. Okay, well, thank you everybody for coming today. And I do want to say, we are going to do this November session with different points of views on this and other remedies questions, and please come to that as well. Have a good
We
day.
have this afternoon at 4 o'clock, the discussion of Jimmy Kimmel.